Hi all, welcome to the A-Level Law Essay channel. In this episode, the essay is going to be covering the chapter Formation of Contract in the Contract Law syllabus, and more specifically regarding offer, acceptance and revocation. Before we begin, please subscribe to my channel for more video guides on essay writing and many other interesting topics. With that said, let's get started with Part 1 Content Guide of Video Tutorial number 11. Question. The question reads, Ian has an antique piano and wishes to get rid of it. He advertised his intention on a local newspaper which stated the starting price for its sale as £20,000 and invited any interested buyers to contact him. Franz saw the advertisement and immediately contacted Ian via email and stated that he is ready to purchase the antique piano. Ian, upon reading the email on the same day, immediately replied Franz and quoted a higher price of £30,000 and said that if he would accept the item for this price instead, he should come to his house to make the payment. Jerry, Ian's next door neighbor, who saw the advertisement the same day after Franz's email, decided to walk to Ian's house to tell him of his interest to purchase the item. After a long discussion, Ian made a final offer of £30,000 to Jerry, who said that he would think about it and get back to him soon. Upon reading the email the following day, Franz went to Ian's house with a £20,000 check. Ian told Franz that his final offer to him via email was £30,000 and refused to accept the £20,000 check for the sale of his antique piano. Franz then tore the check and decided that he should just give in to Ian's demand for a higher price. Before Franz could write out a new check, Jerry walked into the house and handed Ian a £35,000 check for the item, advised the parties on who has the better contractual right to the antique piano. To answer a scenario-based wrong question, it is important to first identify the relevant parties and the issues that they are having with each other. From the scenario, we know that the disputing parties are Franz and Jerry against Ian. Ian advertised his intention to sell his antique piano on a local newspaper with a starting price for its sale as £20,000 and invited any interested buyers to contact him. Both Franz and Jerry, who were interested in the purchase, got in touch with Ian on different circumstances. Now we are to advise both Franz and Jerry as to their contractual right to the antique piano. After identifying these important things, we should then be able to figure out which chapter in the contract law syllabus this question is covering. By the looks of some of the key points in the scenario, it is safe to say that it covers the chapter Formation of Contract, and that it focuses on the topic offer, acceptance and revocation, as we have to determine who has eventually formed a contract with Ian and thereby having the better contractual right to the sale of the antique piano. Introduction. To introduce an essay on contract, we should definitely start off by giving a brief definition on contract so as to set the flow of the content in the right direction. Here, we can briefly define it as a legally binding agreement between two or more persons in a contractual relationship in which parties owe each other mutually agreed obligations. Because the scenario in the question concerns the formation of contract, we should also mention the main requirements for the formation of a contract, i.e., offer and acceptance. The next thing we should do is to briefly highlight the characters and the contractual issues faced by the parties in the scenario. The thesis statement should explain that before we can determine who has the better contractual right to the item, we need to consider if a valid contract was formed between either one of the contracting parties. Point 1. Formation of contract. In any contract question, we usually have to first discuss the formation of contracts so that we can determine the existence of a valid contract. A contract is usually formed when one person makes a contractual offer to another, and the offerer should state clearly what is being offered. This should be contrasted from a situation where a person only makes an invitation to treat. It is important to determine if a person has made an offer or an invitation to treat, as the flow of the answer will then differ because the nature of both concepts are distinguishable. This is especially so when someone attempts to accept something where no offer is made because they do not know that the other person is merely inviting him to treat. This can be seen in cases like Gibson versus Manchester City Council 1979, where the claimant tried to accept an invitation to treat. The highlight of this concept is important because now we can determine if, on the facts of the scenario, Ian has made an offer to sell his antique piano or has invited someone to treat with him. Based on the facts, Ian made his intention known via an advertisement, and it is clearly an invitation to treat, since he only stated a starting price and not offered the antique piano for £20,000. Here, we should contrast bilateral advertisement under Patridge versus Crittenden 1968 with unilateral advertisement under Carlyle versus Carbolic Smokeballs 1893. Clearly, this is a bilateral advertisement inviting interested buyers to contact him about the sale. This would thereby make Ian an offeree to a potential offerer who wishes to purchase his antique piano. Point 2. Franz's case. After determining that Ian's action is considered as an invitation to treat, we now need to determine if the interaction between Franz and Ian has ended with a valid contract formed. For a contract to be concluded, acceptance must have taken place. Valid acceptance requires that it was made by the offeree unconditionally as per the case of Tin versus Hoffman 1973, and that it must have been properly communicated to the offerer as per the case of Antares Limited versus Miles Far East Corporation 1955. Based on the facts, we can assume that Franz must have thought that Ian had made an offer to sell the antique piano for £20,000 and seemed to have completely ignored the fact that Ian raised the price to £30,000. Now, because we consider the initial advertisement as an invitation to treat, then Ian is not bound to sell the item to Franz for the original starting price. Franz's action towards Ian is treated as the proper offer to buy the item for £20,000, and so it is up to Ian whether he wants to accept it or not. Because he doesn't want to accept it, and instead clarified that his final offer was £30,000, we can treat his response as a counter-offer in which, according to the case of Hyde versus Ranch 1840, will terminate the offer to buy the item for £20,000. This will leave Franz with the option to now purchase the item for £30,000. However, because of what happens next, he may not be able to even buy the item for that increased price, even though he has decided to do so. Point 3. Jerry's case. An offer made usually stands for a reasonable amount of time, and after some time has passed, the offer may lapse, causing the offeree not being able to accept it anymore. In fact, even before a reasonable amount of time has passed, the offerer is still entitled to withdraw the offer anytime he wants, so long as it has not yet been accepted by the offeree. This legal principle was established in the case of Payne versus Cave, 1789. Based on the facts of the case, Ian's final offer to Jerry was £35,000 for the item in which Jerry did not immediately accept, but told Ian that he would think about it and get back to him soon. So, applying the legal principle mentioned earlier, Jerry still has a chance to purchase the item at the final price if the item and price is still available. Based on the facts, Jerry did return to Ian with a £35,000 check for the item, and the contention now is between Jerry and Franz, as Franz was also about to accept the item for the price of £30,000. As mentioned earlier, under the case of Payne versus Cave, 1789, an offerer can withdraw the offer anytime he wants before the acceptance. Apart from that, the withdrawal must also be communicated to the offeree for it to be a valid withdrawal, as per the case of Bryan and Co. versus Leon Vientienhoven, 1880. Applying the full principle of revocation into the facts, Jerry has beaten Franz in accepting the offer, though the offer differs between the both of them. Therefore, the offer to sell the antique piano for £30,000 to Franz has been effectively revoked, since it should be obvious to him that Jerry's acceptance has made the offer impossible for his acceptance. Conclusion. Based on everything that has been discussed, we should now briefly point out some of the more salient points to determine who has the better contractual right to the antique piano. Here, we should conclude that Jerry has the better contractual right since he accepted the offer before Franz did. Review. Before we end, let's have a quick review on the content guide. In the introduction, we briefly defined contract law, the requirements to form a contract, and highlighted the facts and issues of the scenario before we moved on to the thesis statement stating our objective for the whole essay. In point 1, we developed our essay by establishing the requirements for the formation of contracts and applied it to the scenario and concluded that Ian intended to form a bilateral contract by way of advertisement inviting any interested persons to treat with him. In point 2, we endeavored to define and discuss acceptance and its legal principles, and then applied to Franz's situation, establishing that since we treated the initial advertisement as an invitation to treat, Ian is free to reject the starting price of £20,000 by countering the offer made by Franz with a higher price. In point 3, we defined and discussed the revocation of offer and applied it to Franz's situation against Jerry's and pointed out that because Jerry accepted the final offer made by Ian before Franz could, the offer made to Franz has been effectively revoked. We concluded it by summing up our discussion and highlighting some of the more important points in the whole content of the answer, and end the essay by stating that Jerry has the better contractual right to the antique piano. That is the end of the content guide for this video tutorial. If you have any questions or opinions on my approach to answering the question, please do comment below. Do check out part 2 of this video tutorial where I will go through with you a sample essay on this question. I will put a link to it in the description below. If you find this video tutorial useful, please like, share and subscribe to my channel for more. Thank you for watching and I'll see you again next time.